Friday, October 21st, was the 25th birthday of the Electronic Communications Privacy Act, or ECPA. And now for a person like a couple of my colleagues who have been checking you all in here, 25 is really young. But in terms of technology, it really is forever. And hopefully, as you've seen from our retro tech fair, and maybe you might have a chance to look at that a little bit more on your way out when we're done with the formal program here, the changes have just been so dramatic in technology terms. And when ECPA was enacted in 1986, Congress really did not and could not have anticipated what the technologies would look like today, and those are the technologies that are regulated by that act. So the Constitution Project, for those of you not familiar with us, is a nonprofit organization here in Washington, D.C., whose mission is to promote constitutional safeguards. And we do that by bringing people together from across the political spectrum and working with them to develop consensus-based recommendations for policy reform. And relevant to today's topic is the work of our Liberty and Security Committee, which was formed in the aftermath of September 11th, and works to ensure that we promote both our national security and our civil liberties. And 3 of our 4 panelists here today are actually members of that committee. So the Liberty and Security Committee Constitution Project has been involved in the issues before us today in 2 ways. First, about a year and a half ago, the committee agreed that the Constitution Project should join the Digital Due Process Coalition. That coalition is comprised of over 50 different high-tech companies and privacy advocates and think tanks, and everybody in the coalition came together around 4 principles for reform of the Electronic Communications Privacy Act. We're going to be focusing here today principally on 2 of those. One, that there should be a warrant required before the government can gain access to the content of your electronic communications. And the second, that a warrant should be required before the government can gain access to location tracking information. And the full list of principles is available as one of the handouts here today, along with the list of the DDP members to date. The second way in which our committee has been involved in these issues is just last month, our committee released a statement on location tracking. And again, the 3 members of our committee here today participated in that effort. That statement focused a lot on the constitutional issues involved, really bringing the 4th Amendment into the digital age, and focused on the location tracking issue, obviously, and concluded 3 things. 1, that a warrant should be required before law enforcement installs a tracking device on personal property. 2nd, that a warrant should be required before law enforcement conducts continuous electronic tracking of an individual for over 24 hours. And 3rd, was actually the second DDP principle, that Congress should amend ECPA to require a warrant for cell phone tracking information. Now, our briefing here today is we bring you as a member of the DDP coalition, urging you to urge your bosses to support legislation that will reform ECPA along the lines of all 4 DDP principles. And our panelists will discuss that in more detail during this briefing, but I just wanted to highlight 2 major messages we want to bring you today. Number 1, as I've mentioned, 25 years in technology terms is an eternity. And one of those computers out there that's from that time could not hold on its hard drive even a single digital photo that you take on your digital camera today. So that just shows how far we've come in technology terms. Second, this should not be a partisan issue. When I introduce our panelists, you'll see that it certainly is not on one side of the aisle by any stretch of the imagination. Reforming the Electronic Communications Privacy Act is something that should appeal across the spectrum, and we hope that there will be broad-based support in Congress for that reform. And also to hit that home, one of the handouts we have available for you today is an op-ed written by 2 additional members of our Liberty and Security Committee, both of them, like Congressman Barr, former Republican members of Congress, Asa Hutchinson and Mickey Edwards, who also advocate this position for the reform of ECPA. So on the Senate side, currently there are 2 bills that would promote some of the DDP principles. And again, panelists will talk a little bit more about these, but just to flag them for you. The first is S 1011, which is sponsored by Senator Leahy, and that's called the ECPA Amendments Act. This bill would address both of the first 2 DDP principles, both a warrant for content and a warrant for location tracking. And Senator Leahy has announced that he plans to mark up that bill before the end of this calendar year. The second is S-1212, and that is co-sponsored by Senator Wyden and Kirk. So we do have bipartisan sponsorship on that one. And that one focuses on privacy of location information. So that's just the DDP principle number 2. The Constitution Project generally supports both of these bills because both of them would indeed advance the DDP principles for reform. So to talk about these issues in more detail, we have a wonderful expert panel. After I introduce them, they'll each make some opening remarks. I will then probably direct a couple of questions to them, and then we'll open it up in case for any of your questions from the audience. So I'm going to introduce our speakers in the order in which they will speak, which they're also sitting in. First, we have William H. Taft IV, who is a retired partner and of counsel in the Washington office of Fried, Frank, Harris, Shriver, and Jacobson. He has served extensively in government, including as legal advisor to the State Department during the George W. Bush administration, as U.S. ambassador to NATO, and as Deputy Secretary of Defense during the Reagan administration. Judge James Robertson will speak next, and he served on the U.S. District Court for the District of Columbia from 1994 until 2010. He also, during part of that time, served as one of the judges on the Foreign Intelligence Surveillance Act Court, or FISA Court. Before serving on the bench, he was a partner at the firm then known as Wilmer, Cutler & Pickering. And he now works as a neutral arbitrator and mediator. Next will be Congressman Bob Barr, who, as I mentioned, is a former member of Congress from Georgia, serving in Congress from 1995 to 2003. He currently practices law in Atlanta, Georgia, and runs a consulting firm, Liberty Strategies, Inc. Also, in his former job history, he served as U.S. Attorney for the Northern District of Georgia, so he also has prior law enforcement experience relevant to today's topic. And all three of these panelists are members of our Liberty and Security Committee. Final panelist will be Gregory Nojine, who is Director of the Project on Freedom, Security, and Technology at the Center for Democracy and Technology, or CDT. And CDT has been really the organization at the heart of the Digital Due Process Coalition, pulling that coalition together. Prior to joining CDT, he worked at the ACLU as Director of the Legislative Office. So with that, I will turn it over to our panelists to tell you more about reforming the Electronic Communications Privacy Act.
Thank you very much, Sharon. I'm glad to be here and to speak on this subject. I should say, first of all, that my children are shocked that I would be involved in such a subject. They are my principal assistants when it comes to tech issues. But when it comes to Fourth Amendment issues and privacy issues, I guess that is where I have the leg up on them. Just a few quick points. The Electronic Communications Privacy Act is not a bad act at all, and when it was enacted originally 25 years ago, I think the spirit of it was very clear. That in the previously the custom had been to keep letters and your correspondence and information in your desk drawer in your house, and the government could not get at it unless they had a warrant from a judge because it was secure there under Fourth Amendment principles. It turned out in the technology age that certain types of information and correspondence, email, has come out of your desk drawer, is stored in many different ways, and is perhaps available for review by the government now in ways that would not require any invasion of your house or a specific physical examination. This is the spirit of the ECPA, was to carry forward the Fourth Amendment, traditional Fourth Amendment protections for what was in your drawer into the electronic age. amendments that are being suggested now and are in the Leahy bill and the Wyden-Kirk bill are actually just in that spirit, but to apply that spirit in a new environment. But the basic idea is that now that information is not only not stored in your drawer, it is not stored in your computer necessarily, that it is actually available often in the cloud and controlled by and have access, the third parties, storers have it, that we need to update what the rights of the government are to get a look at it. The legislation then, as Sharon said, basically there are two issues that I'd like to mention, and they do correspond to the digital due process principles that the Constitution Project has signed up to, but not just the Constitution Project. This is really just a rather extraordinary coalition that we have of business, of individual liberties mavens, and of in fact many law enforcement people. But the first provision, which is in the Leahy bill, not in the Wyden-Kirk bill, relates to getting warrants for email and data that are stored anywhere online for a long period of time, which is not the case now under ECPA, just as would have been required basically if they were stored in your personal computer or in a hard copy in your desk drawer. This requirement for a warrant to be obtained from judicial authority is actually, I think it's important to say, not that hard. If you should have one, you should be able to go and persuade a judge that you should have it, and that's the requirement that this bill would put in. The second area that is addressed, and which is also consistent with the principles of the digital due process group, is that the government should have to obtain a warrant for location tracking. And this is, again, somewhat limited. It's not just location tracking for 1 minute or for a short period of time. It's, I think, over 24 hours is the way the bill cites it. But that where there is, in the new environment, and it's entirely possible for people to know where other people are on a pretty continuous basis, whether by placing something on their car to track them, or by just going to the cell phone company and finding out where their cell phone was checking into different towers over the day, that the government should have to have a warrant. If you have, as in, say, the Jones case, which is coming up in the Supreme Court next month for oral argument, a tracking device that keeps you on and lets the government know where you are for days on end, 24/7. Your life is not your own. Everything you do is evident there, and a warrant, our feeling is, should be required. Actually, this is not so extraordinary when you consider that the government thought the same thing in that particular case, and they actually went and got a warrant to do it. The only reason we have the case is because the warrant had a time limit and they ran out, and they began continued the surveillance without the warrant, and now they're arguing that they didn't need it. But that was not their initial view. when they went and obtained it. An important thing is, of course, that the Supreme Court will presumably decide this case, but on constitutional grounds. Our thought is that whatever the position of the Fourth Amendment relevance to this, and constitutionally, that actually it would be better if the Congress were to address this problem with legislation. They're not limited to the Fourth Amendment if they want to regulate the operation of law enforcement. 2 points, one of which, 2 final points, one of which Sharon made. The first one is that this, regarding law enforcement, this is not in any way going to really significantly hamper the efforts of law enforcement to operate and to protect us and our security. There are in each bills many special recognition, and there can be this can be done, recognition that there are emergencies, that there are special situations, that can be exceptions of very brief duration, but that are available. But beyond that, it isn't that hard to get a warrant if you have a real reason to have one. You go to the judge and you explain your situation, you explain that you have probable cause to believe that a crime has been committed and that this person was engaged in it, and it's issued. The second point, which Sharon did make, is about the bipartisan support for this bill. This is not a partisan issue. I am a Republican. I was a Republican, my mother used to say, before she was out of the ether, and have been one ever since. And there are many Republicans and Democrats who address this as a privacy issue, as a law enforcement issue, and they come to the same place. I think that that's an important feature, and I would just, it wouldn't do the Congress any harm to actually, in this session and in this year or next year, pass a bill that had bipartisan support on an important issue, and I hope they do.
Thank you very much. Before we turn to our next panel, I just wanted to, for those who clarify a couple points, for those of you who are not immersed in these issues as we all have been, just 2 points that Mr. Taft was hitting on are the Supreme Court case, which is looking just at the constitutional issue. That is looking at a case involving a GPS device stuck on somebody's car, and the principles of extending the Fourth Amendment to the digital age and require a warrant is the same. The ECPA would not govern that. Would not govern the GPS device on someone's car. And so even if the Supreme Court does get it right from our perspective, we still need Congress to act here and to further regulate as regard to the cell phone location tracking information. The other just minor point of clarification is the 24-hour limit is something that comes from our committee's recommendations, but that I don't believe finds a parallel in the bill. So, but thank you very much. Judge?
Well, I hope no proof is needed of the proposition that this is a live, unrehearsed program, because much of what I have to say has already been said, but not everybody has said it yet. So you're going to hear some repetition, but repetition is a good way to learn, I think. I have a paperweight on my desk that somebody gave me when I became a judge that said, it was a quotation from Roscoe Pound. Anybody know who Roscoe Pound was? No, of course not. You have to be of a certain age to know who Roscoe Pound was. It shocked me to learn the other day that Glenn Beck has accused Roscoe Pound of being the father of the injection of sociology into law. But I don't know whether that canonizes Roscoe Pound or not, but the quotation is, the law must be stable, but it must not stand still. Well, the ECPA law particularly cannot be permitted to stand still. Just take a look at the technology back there in the back of the courtroom, and you will, those of you who are under 25 will be amazed to see the archaic machinery that was around when ECPA was enacted 25 years ago. In the 25 years since then, there have been enormous changes in the ability of the state and non-state actors to conduct electronic surveillance, to access, to mine, to search, to read the content of electronic communications, and using both GPS technology or cell site information, which is now called CSI, to locate or track people in their vehicles. I am here, like my colleagues are here, to urge Congress to bring ECPA up to date, to consider and adopt the digital due process principles that would not only bring the law up to date, but also provide for the foreseeable future, to the extent we can foresee the future, which in this digital age is not very far. I am a member of the Liberty and Security Committee, and our statement last month concluded that a warrant should be required before the government may track someone's movements using location tracking technologies for more than 24 hours. How many hours is a matter of debate, I think, but that's where our committee came down. or before installing a tracking device on somebody, or as you've seen in the movies, injecting chips in their arms or dropping things in their pockets unobtrusively, whatever, for any period of time, regardless of the tracking period. Now, early next month, the court is going to hear argument in Jones versus United States. Jones presents some, but not all, of the location tracking issues. And as interesting, as important as Jones is, it illustrates why Congress cannot sit back and wait for the courts to find and strike the balance between and among considerations of public safety, digital security, privacy. It's a complicated equation. Jones, in fact, shows that the development of the law through the courts is ad hoc and even accidental. As Mr. Taft says, law enforcement officers did get a warrant, obviously assuming, as we now urge, that a warrant was necessary. Nobody thought it wasn't necessary. But the warrant expired, so necessity being the mother of invention, the prosecutors invented the new theory. We never needed this warrant in the first place. Well, that accidental, that's kind of like the discovery of roast pork, you know, somebody burned their finger and licked their finger and said, oh, that's good. Now, my colleague Ellen Siegel-Huvel, Judge Huvel, had no precedent to guide her except a 1983 case, 3 years before ECPA, which involved the use of a beeper device to track somebody to a drug laboratory. Not on point. The Court of Appeals, but she relied on that and ruled that the police action was not an unreasonable search. The Court of Appeals, in what has been described as a visionary decision by Judge Douglas Ginsburg, nobody's pet liberal, Judge Ginsburg, analyzed the expectation of the privacy issue under the Fourth Amendment, found a constitutional violation, and reversed Jones. Now, the Supreme Court may or may not agree, and if it agrees, it may or may not deal with a privacy issue. It may focus on the seizure question that is presented by placing a device on a vehicle. It may ignore the privacy issue or duck it or not reach it. And as a matter of fact, some people believe they should not reach it. Whatever the Supreme Court does, however, is going to be sliced and diced and deconstructed and distinguished by other cases and other courts for years to come. The DDP principles, the data due process principles, are not ad hoc. They are not case by case. They simply require that the government obtain a search warrant based on probable cause before a service provider can be compelled to disclose a user's private communications or documents stored online, or before it can track either retrospectively or in real time, the location of a cell phone or other mobile communication device. Just a word about warrants. And to reinforce what Mr. Taft said, I retired last year after 16 years in the federal trial bench. For 4 of those 16 years, I served on the Foreign Intelligence Surveillance Court, also known as the FISA Court. I learned most of what I knew about warrants on the FISA Court, because in federal district courts, most warrants, except for wiretaps, and those specialized Title III wiretaps, most warrants are presented to and issued by magistrate judges. If you want to read a really thoughtful and informative piece of testimony on how magistrate judges do it and how they need guidance from a statutory amendment, look at the testimony of Judge Stephen William Smith on June 24th of last year before a subcommittee of the House Judiciary Committee. I've got a copy of it here if anybody wants a precise citation afterwards. Almost all warrant applications are granted. In fact, when I was in the FISA court, the critics complained that the court was a rubber stamp because it had never denied a warrant. But the reason we granted every application was, and this is important, the reason that it's easy to get a warrant, as Mr. Taft said, is because before presenting the application, the government has to step through the requirements and do the job of thinking through and explaining why they need the warrant. The requirement to ask a neutral judicial officer for a warrant acts as a governor on rogue or overly enthusiastic police activity. That's why the warrant requirement is important and why it's not burdensome. Now, again, I'm repeating and repeating, there's plenty of room for exceptions for emergencies, for child porn cases, for consent. Mr. Taft was talking about his was it your daughter? Your children who couldn't believe he was tackling this issue. I thought he was going to say, I thought he was going to say, I can't believe you're going to defend your right to find out where I am in my car. But that's a consent issue, and that would be covered by the statute. So that's what I have to say. I'll pass it on.
Thank you, Sharon, and thank you all for being here. I know from having served over on the House side for a number of years, how demanding your time is, and even more so over here on the Senate side with the number of issues that you all have to deal with. And, you know, this issue is one that, you know, realistically, you could go back and tell your senator or your member, you know, don't worry about this. It's not a huge issue. We're not hearing from a lot of constituents about it. You know, perhaps unless you happen to represent, you know, California or one of the districts out there in Palo Alto where Facebook and Google and so forth are, where you know, it's a very important business issue as well as a privacy issue. So you know, it would be easy to say, you know, deal with other issues, deal with the Jobs Act and the appropriations and the budget cuts and so forth, because that's what we're hearing about. The fact of the matter is, though, that this is an extremely important piece of legislation and can be a very important political vehicle back in states and in districts across the country. Everybody uses devices for which the privacy of those electronic communications is important. Everybody, every single constituent engages in transactions virtually every day for which the privacy of those transactions and those communications are vitally important. The particular reasons why constituents might care about the privacy aspects of what we're talking about here may vary. With younger constituents, of course, it might be the privacy of their social networking, the communications through Facebook and email and texting and so forth. For more senior constituents, it may be identity theft, banking transaction, protecting the privacy of such things like that. Every single constituent has an interest in the private, whether they realize it on the hurly-burly of every day's activities or not, every constituent has an interest and a concern over the privacy of their communications, whether in whatever arena. And even libertarians care about this. I mean, Ayn Rand, just mention Ayn Rand's name, privacy. Go back to the Fountainhead, look at the Work's argument to the jury, that saved him at the end in his trial. It was all about privacy, the bedrock of civilization, protecting people from other people. And the notion that Ayn Rand, for your libertarians in the district and a lot of the strong conservatives, she understood it. You take away, I think she said, take away a man's privacy and you give the government the power to control that person. Absolutely. Privacy is fundamentally important to freedom, and appeals across the board, demographically, politically, ideologically. This legislation that we're talking about, particularly Senator Leahy's bill, is a winner. It's a sure winner across the board for constituents of Republican, Democrat, Independent, Conservative, Libertarian. And it's something that affects everybody, which doesn't mean that it would just go sailing through. I mean, obviously, we have a problem generating support and interest and focus on the legislation. Senator Leahy, his piece of legislation, S-1011, doesn't have any co-sponsors. It's vital, it's essential that happen. That certainly may be generated to some extent if he moves forward, as I believe he has planned, to bring 1011 before the Judiciary Committee this year. It'll be very, very important to get some momentum going into next year. It's also important, I think, from a political standpoint, to realize that this is not a new issue. Greg reminded me that I've actually introduced a piece of legislation 11 years ago. I'd forgotten about it until he reminded me of it. A piece of legislation, H.R. 4987 from the 106th Congress back in 2000. And the purpose of it was to begin the process of doing exactly what we're still trying to do today. This is not a new issue, and we got that bill through the Judiciary Committee. Unfortunately, we weren't able to convince, I think it was late in the year, late in the year, we weren't able to convince the Republican leadership over on the House side that this was an important issue. But it illustrates, and being able to have gotten this bill through the Judiciary Committee on the House side, with very broad bipartisan support, by the way, that this is an issue that can resonate with other members, with other senators, regardless of party. In large measure, I suppose it boils down to simply getting people to think about it. Everybody cares about privacy if they think about it, but they don't always think about it. And you can't simply wait until there's an identity theft or somebody's Facebook picture erroneously goes out or whatnot, and there's all of a sudden a crisis for that person or a group of people, to really do the responsible thing, and that is to address these issues today. Now, it's also difficult because, as we all probably know, even though we may not think about it all the time, the most powerful force in the universe is the force of the status quo. Once something becomes the status quo, it becomes almost impossible to move it, to change it, to alter it, to amend it. But it has to be done, as both the judge and Mr. Taft said. This is important legislation, very important, and it doesn't take anything away from ECPA, which at the time was a very good, forward-looking piece of legislation. It doesn't take anything away from law enforcement or national security, despite the fact that they have this knee-jerk reaction against it. It's a little more difficult to bring them along, but it can be done because the legislation that we're talking about here does, in fact, as it should, provide sort of relief valves for national security and for law enforcement exigencies. But moving the status quo is very difficult, but this is very, very sound legislation. And again, It has and can be sold as truly what it is, completely nonpartisan. It affects all different demographic and professional groups. There are companies. I mean, look at the, as I think was already mentioned, the DDP, the coalition that we're working with here. This legislation and the ideas incorporated and the principles are supported by some of the most prominent commercial entities involved in communications, Facebook, Google, certainly. So those are tremendous resources that can be approached and hopefully work in conjunction with here that reaches a lot of people. There's over 800 million people who use Facebook, and the number is just growing exponentially every day. Couldn't even imagine how many people use Google every day. And yet, if you go to the average person and if you ask them, do you expect that your communication, whether it's over Facebook or Twitter, unless you just send it out to the whole world, and that's something very different, but if you communicate by whatever means electronically with a person or a group of persons that you have chosen to communicate with, if you ask the sender of that electronic communication, do you expect that to be private? They would certainly say, yes, of course they do. And yet we have this artificial notion concocted by the government and a lot of judges that the expectation of privacy is something very different from what the people themselves actually have in their mind, an expectation that when you communicate, just as people used to through the U.S. mails, which, well over almost 150 years ago, 140 years ago, was deemed, the content was deemed private, personal, and the government needed a warrant. It's no different now, but you just have to get people to think about that. And I think this is a very important vehicle, not only for what it does, and that is to further the cause of individual liberty and privacy and limited government, limit the power of the government to intrude in that privacy, but also perhaps to begin the process that should have started a long time ago, and that is to really look at this notion of expectation of privacy the way we as individuals do and the way your constituents do out there, and that is something very personal to them, and to get them to realize that it's very much in danger. Once they open up an email, the government's view is as fair game. We don't have to get a warrant for that. All we have to do is sign a piece of paper, call the subpoena, and go ahead and get it. If these arguments and the reality of the world out there now with electronic communications is presented to people, it's a real winner. So I think that from a political standpoint, from a practical standpoint, this is very good legislation, appeals very, very broadly, and has nothing to do with Republicans or Democrats or independents. Everybody uses these things, has an expectation, needs to have them protected. Just got to get them to think about it, perhaps more than anything else. Thank you, Sharon.
Hi, I'm Greg Notre. I'm with the Center for Democracy and Technology. I want to thank the Constitution Project and the Liberty and Security Committee for putting on this event and for supplying every other panelist but me. So I outed myself as the non-Liberty and Security Committee panelist. I'm going to say a few words about digital due process, the coalition that proposed the reforms that we're talking about today, and then do a semi-deep dive on the Leahy bill and on the GPS Act, the Wyden bill, Wyden-Kirk bill, that would address some of those recommendations. So digital due process was born out of a call, really, by Senator Leahy that industry work with privacy NGOs and with academics to come up with a reform agenda that would update ECPA. He made that call at a CDT event about 4 years ago. It led to literally 2 years of discussions about what we ought to do, what we ought to propose to update ECPA. We started out with a small drafting group of 4 or 5, 6 ECPA aficionados. And we went through about 13 different proposals for reform. Some of them were too hard. Some of them we couldn't get consensus on. Some of it wasn't clear that we wanted to do what we thought we wanted to do. We threw out a lot of them and ended up with 4 reform proposals and dozens of organizations and companies supporting them. The foundational principles for these reforms are that there ought to be technological neutrality. You shouldn't favor one platform over another. The reform should make the statute tech neutral. We wanted to preserve the building blocks of law enforcement investigations. When law enforcement has only a little evidence of crime, it should be able to get the less sensitive, personally identifiable information so that it can build toward probable cause, which would enable it to get the more sensitive information like content. We decided to preserve the existing exceptions in current law. Exceptions, for example, that allow for disclosures without a prior court order in an emergency, that allow disclosures to NCMEC for child pornography cases. We kept in place the cybersecurity exception in current law that allows a provider to, for example, monitor its own network to protect it against damage. Touchstones were simplicity and clarity. We rejected a broad rewrite of the statute early on because we were fearful of unintended consequences. Change a word here, you don't know what it means somewhere else. So we tried to keep the changes tight and limited. And the other touchstone was don't boil the ocean. If you don't have to do something to bring the statute up to date, don't rewrite that section of law, even if you think you could make it a little more clear. Because you don't know, again, what the unintended consequences might be. We wound up with 4 principles. The proposals were released on March 30th of last year. In summary, they are warrant for content, warrant for location, whether real-time or prospective, whether cell site or GPS, true judicial review for pen trap orders, and that means that under current law, if law enforcement certifies to a judge that the information it seeks with the pen trap order is relevant to its investigation, the judge shall issue the order, and the order can cover things like email to from information, or who you called and who called you. We thought that the judge ought to actually make a decision about whether the information sought was relevant and material to the investigation. So we called for that reform as well. And also a court order, as opposed to a subpoena, for obtaining bulk information about obtaining bulk information that is non-content that could normally be obtained with a subpoena. But when law enforcement doesn't have a target, we thought, well, there ought to be a judicial authorization for these bulk disclosures. So for example, law enforcement might say, we want to know who visited this website over this period of time. That would require a bulk disclosure about people who aren't targets. For that kind of request from law enforcement, we thought there ought to be a court order, not at the probable cause level, but a court order instead of a subpoena. Following the issuance of these recommendations, we went door to door in Congress and we asked members to consider introducing and supporting legislation that would incorporate these proposals. I want to talk about 2 bills that go a long way toward incorporating the most important of these proposals. And I'm going to focus most of my time on the Leahy bill, the Electronic Communications Privacy Reform Act, S1011. Major provisions of the Leahy bill are warrant for content, and it doesn't matter whether the content is held by an electronic communications provider or a remote computing service provider. And for people who don't know what those terms mean, I can talk about it after the event. It would do away with the distinction in current law that says that after a communication is more than 180 days old, it loses the warrant protection. It would maintain the warrant protection for the entire life of the communication. And it would rewrite the statute in a way that takes away an argument that once you open an email, it loses the warrant protection that would otherwise attend to it. The Leahy bill also maintains the status quo on notice. So right now, in the real world, people get notice when law enforcement is conducting a search because they knock on your door or they break it down, okay? You get notice that law enforcement was there. In the electronic context, notice is a little different. I mean, your provider is being asked to provide the information, so how does notice come to you? Notice comes only if the statute requires it. And right now, for when you're in subpoena land, a notice is required when the content is disclosed, but notice can be delayed. So we thought, or Senator Leahy thought, well, if we're gonna have warrants, you ought to maintain the notice status quo, and he does that. So you get notice along with the warrant, and the notice can be delayed for the same reasons it can be delayed in the subpoena section that's in current law. I should add that courts are moving in the same direction that the Leahy bill is moving. There is a Sixth Circuit decision that Justice did not appeal that came down in August of last year, the Warshak case, that says the government needs a warrant for all email. The second major provision of the Leahy bill is that it requires a warrant for prospective location information obtained from a provider. Prospective means location information in real time and going forward, as opposed to retrospective location information. Where were you in the past or over this 6-month or 3-month period? Right now, ECPA does not specify a standard, and that has put a lot of pressure on the courts to come up with a standard, and they've been all over the map. The Leahy bill would resolve that uncertainty. And under the Leahy bill, it wouldn't matter whether the location information was generated through cell tower location or through GPS. It would require a warrant for both when it's in real time. With respect to retrospective location information, the Leahy bill would require a 2703D order, specific and articulable facts that the information sought was relevant to an investigation. That's different from what the Digital Due Process Coalition recommended. We thought that that information was as sensitive and that a warrant ought to be required. And like DDP, the Leahy bill maintains the exceptions in current law for things like child pornography and emergencies. The Leahy bill goes beyond the digital due process recommendations on location in one respect. It would require a warrant for extracting location information directly from a device. So we focused on getting information from providers, and the Leahy bill covers that, but goes beyond it and talks about extracting the information directly from the device. As was already mentioned, U.S. v. Jones won't resolve the big issues that are being addressed in the Leahy bill. It might shed some light, but it's not going to resolve them. The Leahy bill is about accessing electronic communications from a device or from a provider, and it defines device in a way that does not include the attachment of the GPS device to the vehicle that happened in U.S. v. Jones. So while the court could have some expensive language that sheds some light on what the standard ought to be under the Constitution for location information, it doesn't directly address the issues that the Leahy bill would address. A couple other provisions I want to mention in passing. There's a significant sweetener for law enforcement on the national security letters side of things. The bill would amend the NSL statute 2709, 18 U.S.C. 2709, to basically give the FBI what it had sought in an intelligence authorization bill in the last Congress. It would make it so that dialing, routing, addressing, and signaling information, which includes email to from, would be available with a national security letter. Providers have been interpreting a DOJ Office of Legal Counsel opinion that's about 2.5 years old now as precluding the use of NSLs to get email to from. It also includes a provision about voluntary disclosures for cybersecurity purposes. In our view, that one merely clarifies an existing provision in current law that allows providers to disclose information to protect their rights and property. A couple words about the GPS Act, the Wyden-Kirk bill, and I'll compare it to the Leahy bill. It focuses only on location, not on anything else. Like the Leahy bill, it requires a warrant for prospective location information. Unlike the Leahy bill, it requires a warrant for retrospective location information. So it goes the full 9 yards in implementing the DDP location recommendation. It also requires a warrant for law enforcement using its own device to find yours, okay, to find your location. So for example, law enforcement can and does place location sensors in different places to find out where a device might be, and it picks up the emanations from the device. It would require probable cause for that kind of surveillance. And I'll stop there. Thank you very much.
Okay, thank you. Well, I want to thank the panelists. I had a long list of questions here I was going to ask you. Most of you covered that in your opening remarks, so I'm going to limit myself. I have one quick follow-up question for Greg Nojon, and then the same question for the other three. So I'm going to start with Greg. You mentioned, and we've all talked about how the DDP Coalition includes a lot of technology companies. Having worked with recruiting all of them, can you just give the sort of quick version of why is this so important to the technology companies, since we don't have them here to speak for themselves?
The biggest concern that they have, I think, is about cloud computing. Right now, a lot of the companies see everything going into the cloud and want a part of it. And it's important to them that they be able to tell their business customers and their consumer customers that the information that they put in the cloud is going to be protected at an equivalent level as if they had stored it locally. If they can't tell them that, then the customer has to say to themselves, am I willing to sacrifice some privacy in order to take advantage of these cool cloud computing benefits that I get? Cloud computing, you can access the document anywhere you are. You don't have to worry about keeping a firewall or doing all this other security stuff. Security vendor's going to do that for you. You can do a lot more, and you can spend a lot less to do it. So I think there's a general view that cloud is the wave of the future, and that leveling the playing field between cloud and local storage is essential for the growth of that industry. I should add one more thing. They want clarity more than anything. The companies are stuck in the middle. There's law enforcement coming to them, making a request, and the way the law applies to that request is often unclear. And they have to spend a lot of lawyer time and and sometimes a lot of time in court dealing with this lack of clarity. So they see a benefit that would also benefit law enforcement in getting some clarity to the law.
Thank you. Okay, so for my other three panelists here, the main objection that I hear certainly when when we talk about these proposals is, aren't you tying law enforcement's hands? Why should we do this? Don't we need these tools to go after the bad guys? So if you could you've touched on this in your remarks, if you could give the quick, what is the answer to them? And then for my two, for Congressman Barr and Mr. Taft, who's spoken some about the Republican, why they should appeal to Republicans. If you sort of the quick, why should this have broad bipartisan support? Why should Republican officers sign on to the Leahy bill? maybe go across this original order.
Okay, well, on that last one, I guess,
I think your mic is.
oh, here we go. On that last one, I don't see anything special about being a Republican that makes you less concerned about these privacy issues that are involved here. This is not something that comes down on different sides of the aisle, as far as I can tell.
On the Republican-Democrat issue, I would expect a Republican to be opposed to these procedures, to these suggestions, if he or she thought it would be soft on crime. There's nothing soft on crime about this. There's no interference with law enforcement. Among the people who want certainty are law enforcement, who are tired of having tired of being second guessed by judges after they've done their best to interpret what the law means. The clearer the law is, the better it is for law enforcement, and the simpler it is, and the more assurance they have that when they make an arrest or investigate a situation, they're not going to be reversed by some court someplace. So certainty works for law enforcement just as it does for the private sector.
Congressman?
You put your finger on a major problem in selling this legislation, and that is, as I think I mentioned earlier, the knee-jerk response by law enforcement, Department of Justice, and the national security agencies. There's an article here from Wired, just released on October 21st. Aging privacy law leaves cloud email open to cops, and it quotes a statement by James Baker, Associate Deputy Attorney General, just this past April this year, makes those arguments. And you could take this, remove his name, and it could be any Associate Attorney General from any recent modern administration. They all take the same position. Any changes that appear to or seem to make it more difficult for law enforcement to obtain information is going to be devastating to law enforcement. The sky is going to fall, and the national security arguments are the same. As both the judge and I guess everybody up here has said, in common sense and following these pieces of legislation and following criminal procedure, as all of us do to some extent, we know that's not true. The sky doesn't fall if the government is made to adhere to the Fourth Amendment and to follow reasonable procedures to acquire information. Two things I think are important. One, getting people to understand exactly what's going on here, because they don't know. The average person doesn't know any of this. They don't know that once you read that email, it is subject to the government obtaining it with virtually no showing of anything at all. People generally think that, well, the government can't take that or can't access it unless they have a good reason, unless they show probable cause. Part of it is just educating constituencies to exactly how easy it is under the current law for government to gain access. Or people don't know that if that there's no protection at all if they send communications to a certain number of people. Educate people as to this. I think another tool that can be used is to use some of the resources that are already out there. There's a very good article in The Hill just yesterday, 2 days ago, the 25th, by Asa Hutchison and Mickey Edwards. I mean, Asa Hutchison, I served with him in the House. Not only was he also a former U.S. attorney, a member of the Judiciary Committee, but he was head of DEA, I think, wasn't it? DEA and so forth. I mean, there are a lot of people out there, including folks on the panel, that have tremendous credibility that they bring to debates and discussions of these issues, and there's a lot of material out there. I think it's very important to use it and to let people know this is not, some cockamamie liberal scheme that somebody has come up with to tie law enforcement's hands. It is common sense, constitutional, important for not only the average person, but for businesses, as Greg said. The businesses that are, the entities that are in this business, they want certainty, they want clarity, they want consistency. And it enables them to both develop new products without this uncertainty hanging over their head. It also allows them to save money and devote those resources that they devote to, not that there's any problem devoting a lot of money to lawyers, of course, but without devoting a lot of their money to, studying every one of these issues and dealing with these issues constantly. If there was a greater degree of certainty and clarity and consistency here, which Leahy's legislation would bring, that's good for business, but in a way that directly impacts the consumer, the users of social networking, for example. So I think those are good arguments to use.
Thank you. So I want to open this up in case you all have questions for our panelists. Anyone? We're so thorough. Yes.
I just have one. Judge, obviously we're dealing with the ECPA statute, not the FISA statute, but I'm wondering if you see any national security issues or areas of concern with the DDP principles, or do you think that the government will still be able to conduct its national security operations, even with these changes to ECPA?
Well, first of all, neither of the bills has any impact on FISA.
Right.
Secondly, I think I can tell you without violating the oath that I took when I joined the FISA court that there's nothing in this bill that that doesn't already happen in the FISA courts. The kind of surveillance we're talking about routinely was obtained in the FISA context with a FISA warrant. So I see no impact at all of this bill or any change at all on FISA. And to the extent that it gets people thinking more about stepping through the right procedural steps to get warrants, I could even cobble up an argument that it enhances national security. That might be a bit of a stretch, but I would make that argument to get this bill passed.
Not a stretch if we're focusing on the real bad guys. That helps law enforcement, so not a stretch at all. Other questions?
Yeah, I just wonder if the panelists could respond to the concern that I hear from law enforcement, which is that certainty is good and everybody benefits from certainty, but if that certainty is a higher requirement for warrants, warrant applications take more time than signing a subpoena. Subpoenas take less time than applying for a court order of any kind. And COPS funding has been reduced to at least another $50 million this year from what it was last year, and budgets are constrained. And that any higher level of warrant requirement will hinder their ability to conduct these investigations, these electronic investigations.
Who wants to?
Congressman, you were a U.S. attorney.
Well, it's an argument that law enforcement always makes. Not all law enforcement. I find that there frequently is a somewhat of a difference between local law enforcement and federal. Local police and sheriffs are much closer to people in the communities and understand, I think, a lot of the concerns and have to deal more directly with the feedback if there's a warrant that's improperly executed, for example, than federal law enforcement, which is somewhat insulated. But it's a very good point, and I don't think there's anything that any of us can say or that any of your principals could say that will stop law enforcement from making those claims. I think the important thing is to be able to rebut them. I think, as Sharon said, it is not a stretch. The judge was, I think, just kidding about this. It's not a stretch that this legislation actually benefits law enforcement, benefits national security, because it avoids, I think, by forcing law enforcement to think a little more carefully about what they're doing, not just sort of throw out 50 subpoenas there just to get some stuff, and they've still got to do something with all that. So I think it does create a greater degree of efficiency by forcing law enforcement to pay more attention, organize themselves, get their case together, as the judge said. I think it was Judge Smith that he referred to, testified about the process. Government, yes, I heard it when I was U.S. Attorney, that agents would whine about the need to go through the affidavit and modify it and so forth. But in the end, they would come back and they would thank me as the U.S. Attorney, and thank the assistant U.S. attorneys for forcing them to do a better job, because it makes their case stronger and it avoids, to a large practical extent, a lot of wasted time by making that sooner or later they're going to have to do this work. They can do it at the beginning and save time by streamlining a case and focusing a case, or they can do it in the lead up to a trial, which takes a great deal more time. So those are some of the arguments that I used when I was U.S. Attorney and have used since then as a defense attorney and as a legislator.
I'm going to add on two other points. One, you mentioned the time. The legislation would certainly preserve the exigent circumstances exceptions, so that should not be an issue. And the other is, the legislation is designed to carry the Fourth Amendment safeguards into the digital age. Law enforcement has tried to benefit from changes in technology that make things easier, but we're supposed to have Fourth Amendment safeguards. Going back, as Mr. Taft was explaining, to the paper in your file cabinet, they would have had to have obtained a warrant. So maybe the Fourth Amendment does require a little bit more work, but it's supposed to. That's the safeguards that we have that we're trying to protect.
Further on that point, and in further response to your question about FISA, you may recall that that there was a considerable criticism of the whole FISA process after the Moussaoui arrest, and one of the criticisms was that you had to go through too many hoops. It was too complicated to get the warrant, and because it took so much time to get the warrant, it was so complicated, and you had to go through so many bureaucratic levels that for want of a nail, the shoe was lost, and they just never got to the point of getting the warrant. That might have interdicted the whole 9/11 thing if Moussaoui had been arrested. Well, there is some truth to the proposition, and I observed this at first hand. There is some truth to the proposition that obtaining a FISA warrant is complicated. I mean, the warrant applications are thick, and it takes a lot of levels of review. And but that's not an argument not to have a warrant. It's an argument for making the warrant application process simpler and more streamlined. I always thought, for example, that it would have been possible, and it still is possible, to have a judge available in real time in a threat center to respond to an application that's made virtually on the spot. There's a lot of ways in which warrant application processes can be made simpler and faster and cheaper to do. So that's one other form of rebuttal to this law enforcement objection.
Any other questions? Okay, thank you. I would encourage you also, if you have a few more minutes, to play with the toys in the back and have a look at the retro tech fair, so you really can see how far we've come in terms of today's technology. And if you join me in thanking our panelists.
No, I actually have to go to work.
You got
So,
don't have